Participated in these little scams, so you know she's just helping her buddies out.
Be the sole party with the sole claim to the payment stream. Debt,
Right.
aka intangible obligation.
Well, this is just saying again, you know, you have to abide by the chief. 7-501. You have to negotiate, transfer, and sell the entire paper mortgage package. Okay?
I'm counting felonies committed by these white-collar criminals. I think we're at 3 felonies here so far. They've done all these things. Is there another slide?
Okay.
Mortgage-backed securities fraud.
Okay, so this is kind of a picture of what they did here. Essentially what they did is they said, we're not going to the state of California door. What we're going to do, we're going to skip the California door. We're going to go ahead and strip the debt from the paper note. We're going to turn it to a binary computer file, and we're going to send it over to Wall Street with illegal electronic copies of the paper note and deed of trust. And then we're going to go ahead and sell it to the unsuspecting investors. And we're going to grab their money, and no one will know. No one will know. And then what we'll do is we'll have the homeowners' monthly payment streams go and pay our contract involved with these securities fraud in the security market. And then if the homeowner defaults, then we'll steal their home because we'll hoodwink everybody.
Wow. This is massive white-collar crime, and this explains why we had the real estate crunch, at least in part, and why they needed a bailout. Because and if they made 100% copies, which is another felony, you cannot make a copy greater than 76% of the original wet ink original. If it's 77%, that's a felony.
Yeah, there is no law that allows what they did as far as making the illegal electronic copies of the paper note and deed of trust and then sending it over with a binary computer file of the debt stripped from the note without ever going to the state of California.
But there's nobody on the internet checking them as these things go electronically, whiz, 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 whiz in milliseconds. Who's checking them? Nobody.
And that's the reason why someone brilliant came up with 15 USC 7003 is because they said, oh, wait a second. You know, we got to make a law here that they cannot make illegal electronic copies of the note and deed of trust because if we have that over in Wall Street, they can sell it 10 times because there's nothing on record showing who actually owns that debt. So that's why it's illegal, and that's why I stood in that courtroom and said, no, I wanted to see the accounting. Because number one, there's a felony crime here, and I want to see where is my monthly payments going. I mean, I go to work every day.
Did your judge or your crooked judge order them to provide the accounting?
No, both Catherine Bauer and Kwan and Ferguson were protecting them, and including the BAP courts also.
Ferguson too?
Ferguson, yes.
He was on Obama's appellate court in the 9th District Federal. I was there. I was watching him. He was one of the 3 judges that finally said, we don't have authority to decide whether Obama was illegally elected.
Well, now we don't know why.
Well, I guess we do know why.
Yeah.
The different puppets, but the same puppet masters are the Wall Street bankers.
Right.
They're getting away with white-collar crime. I don't think anybody's ever stole this much.
But not anymore, because I think that now that we all know, we're not going to stand. I mean,
this makes Jesse James look like an ant.
You know, but the bottom line is, again, they need to understand they are our equals, and they have no right to do this to us.
How are we going to hold them accountable?
What can we do? Understanding the crime. We need to thoroughly understand the crime, and we need to start educating our law enforcement as well. And also, we need to stop saying that it's a civil issue. It's not a civil issue. It's a very serious felony that's been committed. We shouldn't be losing our homes. It's a federal RICO. It's an organized crime. What is happening is the servicers, they may own maybe some part of the unsecured debt involved with securities fraud, but that's about it. But because it's a security, it's non-recourse. Like any stocks that you buy, if you lose your money, it's like playing Las Vegas. You lose your investment. Same thing. Anybody that bought that unsecured debt, they can't access our homes. It's unsecured debt. It's a felony. It's breach. It's
so you could file a bankruptcy Schedule F and get rid of the mortgage loan as an unsecured debt. Unsecured debt once you find that they've committed these felonies.
Yeah, and don't get pushed around by the judges like I was.
Well, I don't think you got pushed around too much because you're still fighting.
I'm still fighting, right? Yeah, I know, but. Yeah, but they're really good at convincing other law enforcement agencies, oh, well, you know what, I'm the federal judge, so I'm going to allow them to take her house.
Yeah, well, I saw that happen with Teddy Sheldon's house too, and she didn't even have a bank loan.
Yeah.
They took her house and was free and clear, and they took her house.
Yeah. So, another thing too on there, I think that I discussed also public banking. I think that we should work together to form our own public banks.
I mean a state-owned bank.
A state-owned-
a state
owned-
central bank.
Yes, owned by the people.
Well, North or
Yes.
South Dakota has one of those, and they've been making loans, and they're not in the trouble the Federal Reserve is.
Right, and what I think is, as you know, most of these banks, what they do is they monetize, whether it's a car loan, a credit card application, it's like 10 times the face value. So if we had our public bank, what we could do is we could take some of those monetized funds and reinvest it back in the community and education, definitely. We need to get people more educated to build the skills necessary to get our economy up and running and viable businesses. So I think that's about it. And at this point, I think I'd like to bring on Joe Escoval, who
Now we're getting to forensic audits, right?
Mortgage compliance investigators.
Right.
Joe is a private investigator that understands this crime very thoroughly.
So if you're a homeowner and you suspect, because you see the original note and you see a blank line, or you got a trustee and there's no person in there. So what would you estimate? 20% of these banks are engaged in fraud, 30%, 50%, 60%?
I would say that probably 97%.
97% of the loans could be eliminated if the people just asked to see the original documents and brought a investigator who's qualified to do it? Is that what we're saying?
Well, you would want to definitely look to see the path of your payment stream and look at the public records to see whether or not it adhered to the state of California requirements. Escoval.
Escoval, a call.
Hello.
Hello, Joe Escoval. This is William Wagner on a live broadcast on television in Santa Maria, California. Could you tell us what you do, Joe?
I'm a licensed private investigator for mortgage compliance investigators, and I deal with issues pertaining to chain of title.
And when you find the chain of title has been broken, do you write a report for the homeowner or give them an affidavit?
We do reports for homeowners, HOAs, investors. We do reports for all different types of people.
And do you give them a report or an affidavit that'll stand up in court?
Well, what we do is a little different. I mean, what I put out is an analysis. It's an educational analysis, along with a factual affidavit.
Okay.
Because the factual affidavit states my findings. I have looked at a note. Okay. I see an endorsement from party A to party B. I look at this note. I see an incomplete stamping as well from party A to an as of yet unnamed payee. I look at a document in Orange County record pertaining, purporting to be an assignment of deed of trust from party A to party B. So the actual affidavit is a factual affidavit stating facts of the documents that I look at. The analysis and investigation that I do lays the foundation in which the parties can start any action that they wish to take.
Would you recommend a quiet title action?
When you have to understand, quiet title is both a remedy and a cause of action. Many people have a misunderstanding that they file a quiet title action and it's a silver bullet that fix all, but they really have no idea of what they're doing. Why would you file a quiet title action when a third party has a color of title claim on your property? In my opinion, better to get a status quo determination as to the status of these parties prior to going after quiet title. And I would do that in the form of possibly a declaratory judgment, all right, as to having the courts determine, does this party have a proper claim to rights to title to my property? Because color of title is not the same as legal title with legal rights.
Right.
Big difference.
How long does it take you? I mean, we can't mention what you charge for it, but how long does it take you? Once, say somebody comes to you on the 1st of January and says, you know what, I'm not being foreclosed on, but I just had my loan traded 6 times last year and I've sent it to 6 different people and I'm not sure I really have to pay them. Now, they're not in foreclosure. No one's filed a notice of default. And they come to you on January 1st and they give you the whole copies of everything they've got, and it's a complete copy, but not the original. How long would it take you to read through that? How many hours before you would come up with a report and possibly an affidavit of wrongdoing?
Our turnaround time is about 10 business days. I mean, there's a lot of work involved, but you have to understand what you're asking. And when you're stating that, the loan has been sold 6 times, you need to, understand what is a loan. Because a loan, we talk about the loan instrument, which consists of the tangible promissory note, which evidences the debt, which is the intangible payment obligation.
Right.
Right.
The banana inside the paper stream, yeah.
Correct. And then, and also we need to be talking about the security instrument being either a mortgage or a deed of trust, or if you're in the state of Georgia, a security deed, all right, which attaches to the obligation, which is evidenced by the tangible promissory note, because you need to have all 3 in order to be a holder in due course. There's a misconception when they say, well, my loan's been sold, or, there's an assignment. Well, what is an assignment? The purpose of an assignment is to memorialize the transaction pertaining to a negotiable instrument in the acquiring of rights. It does not cause the sale. The sale is caused pursuant to statutory requirements of law. So, when you look at all of these documents, all right, when LTW falls off the wall, you cannot put them back together again, and that's what the banks are attempting to do by filing such documents into public record. But when you file these documents into public record, all right, I mean, there's many laws that are being broken. You have 11, just a plethora of violations. I'm not even going to get into. But it's the act of recording this document that is no longer, that was never eligible to be recorded. All right? Because when you record something into public record, all right, it's an act of recording that document where you're slandering many times the title of a party that has legal title. That assignment of deed of trust, for example, in California, they're putting a claim to title to this property. They're saying, hey, we're doing an assignment of deed of trust. And then, in a little forefont, it says together with a note and all obligations due. But the problem is that if you understand what this document actually said, and that you understood that they cannot, all right, do what they're stating. So they're defrauding public record, and then they put these documents into court, all right, and they're defrauding the courts, all right? Many times you've got parties such as murder.
Yeah, fraud on the court is considered generally by most legal scholars to be worse than murder, because it devalues the credibility of the entire court system. Where a murder of one person doesn't devalue the entire court system, but fraud on the court. But from what I'm seeing and what I'm observing is there is massive fraud on the court happening all over. And
but it's not brought forth properly. That's the problem, right? Because for you to just make a statement of fraud, right? And people do it all the time. Oh my God, Joe, I got wrong foreclosure. Well, sorry, it's not a proper cause of action. If you're going to state fraud, all right, and even if you are a pro se litigant, or if you're an attorney, all right, they're making mere allegations, all right? And right now, all right, with the stricter requirements for heightened pleadings, all right, if you're going to state fraud, cite all 5 elements of fraud. Cite A, a false statement of material fact. B, knowledge on the part of the defendant that the statement is untrue. C, intent on the part of the defendant to deceive the alleged victim. D, justifiable reliance by the alleged victim on the statement
Right.
because they're going to throw it out.
So you have to state that in your motion that you file
In
and
your claim,
in your claim, and you also
your
have to
cause of action. Right.
you have to have your attachments to prove each element.
Right. I'll give you an example. Okay, so if I'm going to cite, say, a particular document, all right, with mine, for example, okay, there's a document pertaining to, purported to be an assignment of deed of trust dated blah, 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 in the official records of blah, blah, blah. Okay, county recorder's office. Well, that is a communication of a third party of a false statement derogatory to the plaintiff's title, and it's made with malice caused an injury to the plaintiff's claim of title. All right, and then I go into what makes it. How does it fit into the elements of fraud? Well, let's see, the statement in county record is in a document purporting to be an assignment of deed of trust dated, whatever date, stating that MERS could assign the note or notes described or referred to, and that's a false statement of a material fact because MERS knew or should have known that it could not assign the note pursuant to statutory requirements of law. MERS was never the owner of the note. MERS intended to receive in public record that it could assign the note. And the plaintiff and the public relies upon public record to know other claims of title. Now, as a result of the MERS false statement, the plaintiff's claim to title is devalued.
That's what Valerie Lopez was saying.
Yeah, so now go into the actual MERS documents. When you go into the MERS documents, many people, if you read what MERS says, okay, if you understand MERS in their own documents, all right, go into the MERS procedure manual, which is version 19.0 and is dated June 14, 2010, page 63. It states, transfer beneficial rights to member investors. Overview. Quote, although MERS tracks changes in ownership of beneficial rights for loans registered on the MERS system, MERS cannot transfer the beneficial rights to the debt. The debt can only be transferred by properly endorsing the promissory note to the transferee. Okay, now you can also go to the MERS residential marketing kit, all right, in which there it states under the terms and conditions. MERS shall have no rights whatsoever to any payment made in an account of such mortgage loans, to any servicing rights related to such mortgage loans, or to any mortgage property securing such mortgage loans. MERS agrees not to assert any rights. The MERS system is not a vehicle for creating or transferring beneficial interest in mortgage loans. Now, go further with that pursuant to the maximum of law, nemo, dat, quod non habet. One cannot sell what one does not own, but yet they do it all the time. So you've got a lot of hypocrisy going on. And the problem that we've had many, many times is that the parties do not, the homeowners, the attorneys, do not bring forth complete arguments. I mean, just look to Nevada. Look at MERS versus Edelson. You had an attorney that brought incomplete arguments. And they did it, and they just paused halfway. They went to a gunfight with the butter knife, and they got their butts kicked. Because we're relating, to the courts, and all we're citing are citations, we need to go to statutory law. Don't go to common law, go to statutory law. Many times you hear, well, you know what, Joe, the mortgage follows no Carpenter v. Logan. Has anybody ever done their homework? Do you realize that Carpenter v. Logan was done in 1872? All right? We didn't have the Negotiable Securities Act until 1881. All right? That act was based on common law, not statutory law.
You mean 1981?
1881.
1881.
Right. Carpenter v. Logan was 1872. All right? The Negotiables, all right, Instrument Act was 1881. All right, and then Uniform Commercial Code came in 1961. And then all of the states have their own equivalents to that. All right? So California has their own state's equivalent to the Uniform Commercial Code. Nevada has their own, Florida has their own. So, if you're in California, you go to California Commercial Code. If I'm in Florida, I'm going to go to Florida State's, code under 673 for, say, negotiable instruments. If I'm in Texas, I go to Texas Business and Commerce Code. So depending on what state you're going to, you use your state's equivalent to the Uniform Commercial Code. So many times, everybody is citing citations that are incorrect. I say, go back to statutory law. Go back to what the statutes say. The statute says you can do this, you can't do this. When you're talking about title, when we're talking about property, right? We're talking about a tangible instrument. We're talking about a note. Right? We're talking about the debt, which is evidenced by this tangible promissory note.
Joe,
When
have you seen attorneys bring in the wrong law into court? Have you seen it with your own eyes?
Time and time again.
So
Time and time again.
people should not rely on just any attorney they find to file correctly to get their house free of these fraudulent mortgages.
Well, it's not free of fraudulent mortgages. All right? If you understand, the act of foreclosure, all right, is an attempt to collect the debt. That's what it is. All right? So the banks lose an alternative means of collection. There is no such thing as a free house. All right? There's a loss of an alternative means of collection. That is the purpose of the deed of trust or the mortgage, an alternative means to collect a debt. All right? But it must be properly secured to the obligation that is evidenced by the tangible promissory note.
But once they've separated the payment stream from the note or the assignment of trust deed and electronically transferred it, they've devalued the note. So what other way do they have to collect the debt once they've destroyed or devalued the note?
Well, you have to understand, you can sell the debt all day long. That's under Article 8. All right? You can do that. Imagine if you have a strip shopping center, okay? I'm in LA, all right, and I've got a strip shopping center and I've got 10 stores. And I've got tenants in those stores, and I'm falling behind on my bills. And I don't know what to do. And suddenly I wake up one night and I have an epiphany. Wait a minute. I've got leases. Guess what? I can sell the leases. The leases are a right to collect future monetary obligations. All right? Now, you sell those leases. You still own the strip shopping center. Okay? You've sold the right to collect future payments. Look at credit card debt. You hear credit card debt, student loans, fleet leasing. All right? They sell the debt. That's legal. All right? The problem is that if it's not properly evidenced, all right, is it properly secured? Was there a UCC-1 finance statement filed with the Secretary of State? Was there a proper party in public record? No. The MERS the Mortgage Electronic Registration System Incorporated is an electronic registration database. That's it. It is not, they perceive it to take the place of county recorders, but yet every time someone does a sale of real estate, what happens? You have closing after closing, they take the papers from title and they go file them in county record. Right?
Right.
If we're going to continue to use county record in the county recorder's office, right, what the hell are we using MERS for? It's just about greed. It's about a false illusion of what it purports to do.
Got it.
Just because you file a document in public record, all right, that act of filing it in public record does not cause a transaction.
Okay, Joe, you want to go through the graphic now?
Sure. Yes.
You know what?
One more thing.
Joe, can you hold on 1 second? There's two things that you need to cover like in 15 minutes. The first thing is the infographic, and then also a lot of people are interested in your knowledge regarding bankruptcy, taking the unsecured debt through bankruptcy, and then also 11 USC 524A2.
Okay, well, first off, you have to understand in bankruptcy, the whole purpose of bankruptcy, in my eyes, I'm not an attorney. I'm not giving legal advice, but bankruptcy is to give someone a fresh start. All right? So if something, right, I use me as an example. All right, so if I discharge a debt, all right, one, you have to understand when you file bankruptcy, all right, you have a set of schedules in which you put your property. All right, so when you put your property in there, you have determination of you list whether your property is secured or unsecured. Well, just looking at the bank rules, it says, all right, pursuant to BK Rule 3001, subsection D as in dog, all right, that any party coming forth with a claimed interest in a security certificate or a security instrument must be evidenced by a properly perfected lien. How does one properly perfect a lien? By filing into public record. Well, let's see. Is Fannie Mae named a public record? No. Is Fannie Mae named to the note? No. Yes, they're not a properly secured party. I'm going to put them on Schedule F as in Frank, unsecured, non-priority. All right? Now I go and I get my debt discharged. All right? Under Title 11. All right? I'm going to go get my debt discharged. All right? And when I get the debt discharged, okay, the debt, all right, now has a zero sum, all right, that is owed. Right? Because they say, okay, yeah, you discharged the debt. All right? The problem is that many times in California and other states, they still come forth and do a notice of default. Well, wait a minute. I've discharged this debt that was evidenced by the tangible promissory note. When I've discharged that debt, there's a zero sum due. There was never a properly perfected lien because a properly perfected lien will survive a bankruptcy. All right? So that court order, all right, is an injunction of federal court. Now, if you look under 11 U.S.C. Section 524A2, and that's under effective of discharge, which states under A discharge in a case under this title, then we go to 2, says, operates as an injunction against the commencement or continuation of an action, the employment of process, or an act to collect, recover, or offset such debt as a personal liability of the debtor, whether or not the discharge of a debt is waived.
Okay.
So they're violating this injunction when they're filing an NOD and coming to foreclose, because foreclosure is a form of collection of debt that no longer exists, that has a zero sum due. So now you also have slander of title, you have fraud, and you have violation of 11 U.S.C. 524A2.
How many felonies is that? Joe, how many felonies is that?
I'm not going to say, again, I'm not an attorney, but I recommend somebody to,
take
do
a
your
guess.
due diligence like I do.
Take an educated guess, Joe. You're entitled to take a guess. There's freedom of speech. We only got 6 minutes left.
Well, you're looking, again, you've got slander of title, you violated.
One.
You violated violation of the bankruptcy injunction, and you have fraud. All right, and then you've got 15 U.S.C. Chapter 47, 1021, all right, which states anyone who knowingly records or does not record a document, all right, which we know that they knew they recorded a document which they did not have the authority to record. Thus, the act of recording that document slandered the title to the property. I mean, you've got a number of you have.
So that's at least 4 felonies. We're looking at least 4 felonies by the white-collar bank criminals. And yet the homeowner doesn't know any of this because they haven't done a forensic audit.
Well, it's not forensic audit. I mean, forensic, you're going to numbers. And analysis is what mortgage compliance investigators does. We do an investigation and analysis pertaining to whatever state you're in.
And you get it done in 10 days or thereabouts.
Approximately 10 business days is what we do.
Okay.
And again, these infographics that you have up, we've created a number of them. So in layman's terms, if you look at the one that you have up, which is, I believe you have the RMBS one up right now, Valerie?
Yes, we do. I think, do we have the camera on it?
Yeah, just a moment.
Okay.
All right, so take a look at it. And again, this is very basic. So then when you're looking at it, we're October 24th of '06. So you have the Doe note and the Doe mortgage or deed of trust if you're in California. All right. Now, after closing, all right, the note is sent to the county recorder's office where it's recorded, indexed, filed. All right.
Right?
And then now after that, they send it back to the lender. All right. Now at that time, you have a properly perfected lien. All right. And the lender or originator, right, scan into a system. All right. And then many times they put a stamp on it that says page the order of as of yet unnamed payee. Right. Now, at that time, the intangible obligation is ripped out and sold. And it's sent to a sponsor, if there's a sponsor, depositor, right? Depending on what the PSA says, the pool and servicing agreement. There's a number of transactions that must take place in order for this to be into a RMBS, residential mortgage-backed security. All right, so in order for this to be a REMIC, a real estate investment mortgage conduit, and fall under the IRS codes under Title 26-860D, all right, certain things must happen. It must be two transactions out, two on-site sale transactions, all right, the trust, all right, prior to being able to act as the trust must have all the assets in it by the closing date. That is in IRS publication 938. IRS publication 938 is the publication that is filed with the IRS. All right, when they set up their REMIC to do business, they put it into public record. Hey, IRS, we want to be a REMIC. Right? We want the status where nobody has to pay taxes until it goes to the certificate holders. So we get all of these tax loopholes. And then it's filed in the SEC if it's publicly traded, right, on the secondary market, right? And that's where you have the 424B5 rule. And it goes into a prospectus supplement. And where it states, all the assets will be in there by this date. Now, what many people have a misconception of is that the note will be in there, all right? Read the PSA is what I tell the people. Because if you read the PSA, it says, okay, the sponsor shall sell to the depositor. The depositor shall sell to the trustee. And they name these parties within the pool and servicing agreement. So in this example, it says originator, Nation Point. The sponsor is Merrill Lynch Mortgage Lending. The depositor is Merrill Lynch Mortgage Investors. The trustee is LaSalle Bank. Now, what they are doing is ripping out this intangible payment obligation, and the intangible payment obligation is being sold electronically. And while it's being sold, they're using swap certificates from party A to party B, because many times you'll see within the pool and servicing agreement that says, the sponsor shall own no assets. The depositor shall own no assets. Because they want to keep themselves bankruptcy remote. But all of the transactions that they're doing are not pertaining to the tangible note. They're pertaining to this interest of the note, which is ripped out, which is the payment obligation. So when you look at the third box down, it says the Doe note, and it shows this little box being ripped out. And then you see the arrows going down to the sponsor,
Right.
and then the arrow going down to the depositor, and the arrow going down to the trustee. What is sold is this intangible payment obligation, as done under Article 8. Right? Because it says the assets must be in the PSA. And if you actually read the PSA, it says, the deposit shall sell to the trustee its interest in these loans. Well, the interest was a intangible interest, and he sold that interest. Did it comport with statutory law? No, not always. Right? But, again, this is what the banks have done. They wrote these for the benefit of the banks. They didn't write it for John Doe that was investing in it. The whole purpose of these REMICs is to have a special purpose vehicle where multiple different types of investors can invest in. Right? So they have 20 or 30 tranches, and they have 3 or 4 groups within this REMIC. So what that means is that you can have multiple different types of investors all investing in this this one trust. So depending on what sort of investor, if you want to be a conservative investor, then you're going to invest in, say, Group 1, meaning that you're going to get a set amount, all right, every month, and it's going to be, say, 3% of all the principal and interest for, tranches 1, 3, and 5. And you're going to get that set amount every month. And if you were to say Group 2, all right, you may get a different rate, and you're only going to get, all right, principal interest is going to pay more, all right, but there's more risk associated with it. And if, say, you're in Group 3, all right, which is the junk or the mezzanine, all right, because you get paid last, all right, it is these classes, all right, which support the senior tranches. They get paid last. And they may only have a shelf life of, say, 1 year, 2 years, 5 years, 10 years. And
Wow.
this is where many times when someone would look at a Bloomberg screenshot and say, oh my God, Joe, there's 30 tranches, 5 of them are paid off. My
Got
loan
it.
was paid off. No, your loan wasn't paid off. The tranche was paid pursuant to the underwriting agreement and the pool and servicing agreement. Underwriting pertains to the prospectus supplement.
Joe, we got 1 minute. We got 1 minute left to summarize.
All right. Securitization is legal. The problem is it was never done correctly. You need a chain of title analysis in order to get it done correctly. That's what mortgage compliance investigators does. If you have any questions, you can call mortgage compliance investigators.
Can I give out a phone number for you?
888-491-3741.
Thank you very much, Joe.
Thanks, Joe.
Appreciate you calling in.
All right. Have a great evening. Thank you.
Thank you. Well, people, you've heard it from Valerie Lopez, who used to have her own business. Now you heard it from a investigator who specializes in it. If you have a home loan, whether you're in foreclosure or not, wouldn't it be a good idea to check and see if they've committed fraud?
Oh, absolutely. Especially with so much going rampant
There's
right
so
now.
much rampant fraud and so many crooked judges looking the other way. You need to know if your crooked judge is going to screw you before he comes up for re-election. So we need to do this. The RICO action, that's a whole nother show, Valerie. We're going to have to do that a separate time because we're just about out of time, people. Valerie, I want to thank you so much.
Thanks for having me back.
I'm so glad you came back.
So am I. My bananas.
You got bananas. We
Yeah.
got guinea pig banana food here. I just love this cartoon by BizarroComics.com. You know, this justice system. If we could flash this up again, this is, you know, one guy's asking, how much does the justice cost? The guy's at the vending machine saying, hey, just keep putting money in until you're broke and hope for the best. And people, I didn't get to ask Joe, but I think I would recommend before you hire an attorney, hire an investigator to look at your paperwork, the complete package, if the bank can even give you a complete package. And what I didn't get to ask Joe is if an affidavit of lost note is the same as the real note. Does that suffice? It's like, do I have a Xerox copy of a $100 bill? Is that as good as a $100 bill? I don't think so. What do you think Joe would say?
Oh, absolutely not. He would, yeah, he has something to say about it. We need to get him back.
Yeah, we just didn't give enough time to cover all the bases. But people, a lot of you are losing your homes, and I hope you paid attention tonight.
And I'm Pamela Wistrom. Thanks for being with us tonight. See you next time.
You got the number there, Joe. And if you want to see the show again, look for it on YouTube. Today is December 5th.
Yay.
Thanks for watching. We'll be right back.